Yes, I'm channeling my
Channeling the inner Hillary.
said thank God. Opposite societies.
Oh,
Yeah, whatever.
All right, good morning. Welcome to the 294th District Court. My name is Judge Chris Martin. I'm going to call this morning's criminal docket. If you hear your name, please respond and raise your hand so I can mark you as present. Detriana Baker. Make sure I hear you because I might not look up. Wayne Crump. Sean Earl. Lisa Holdren. Alicia Joyner. Thomas Norman.
Judge, he's here.
Marshall Parker. Marshall Deshaun Parker. Alfonso Perez. Josue Rodriguez. Todd Sane. Claude Souls. Claude Raymond Souls. Kenneth Taylor, CR 22.95 on April 24th. Yes, that was yesterday. It was verified in Russ County. So we'll recall that one. Shane Taylor.
Here.
Cody Wheeler. Carlos Gatlin. John McLeod. Jordan Owens. Jordan Dion Patillo Owens. I know that Mr. Cooks filed a motion for continuance, but that was denied by the court, so assuming that you can be here. Call Mr. Cooks' office to find out. Kaylin Cheatham. Thank you. Jesse Epperson. William Goldner. Joshua Chanel. Randy Dobbins. I'm sorry, Randy Lee Dobbins. Randy Lee Dobbins.
Judge, I was recently appointed on this case. I've been in communication with him via email, so I'll check in and see. He was aware of court dates that he made his own.
Thank you, sir. Noemi Escobar. Ivan Molina Hernandez. Ivan Molina Hernandez. CR 2363 Shauna Henry Newton. Set for arraignment, waiver of arraignment filed and approved, pretrial set June 27th. CR 2384 Daniel Lee Wolverton. Arraignment, waiver filed and approved, pretrial set June 27th. Edo Benjamins. Seth Atkins. Julie Pullins. Christopher Watson. Bolton Green. Carl McVeigh. Daniel Payne. Ivy Sutton. Isaiah Valencia Fulton. Benjamin Miles. All right, is anyone here expecting to hear your name, but you did not hear your name called? Your name, sir? Last name again? Lopez? Lopez, do you have an attorney? Who's your attorney? Anyone else who's not heard your name? Mr. Lopez, will you step outside with Miss Tabran here and she's gonna look your case up, and we'll give you more information. All right, counsel, do we have anyone that's agreed or ready? Mr. Elliott, you ready?
I didn't see your name.
Jesse Epperson, CR 2296-97. Set for docket call today. Any announcements, Mr. Elliott?
Yes, Your Honor. Flexible time with Russell, take a lot of contact. If there's any way we could reset docket call to see if we can reach this, I believe.
Judge, that's our agreement. Obviously, we've gone back and forth about this case a number of times. I think we're pretty close. We just really need to figure out if we can get there. If not, we'll probably just have to set it for trial. We've also discussed possibly moving it downstairs so we can try it faster. So those are discussions that we're ongoing as well.
All right, court will set Mr. Epperson for a final docket call on June 13th. Final docket call means that court will expect to hear from both parties, whether we have an agreement or we're setting for trial. Mr. Epperson, are you on conditions of pretrial release? Have you been meeting with Mr. Waddell, drug testing, reporting, things of that nature? All right, well, you're going to start doing that today. Okay, so once you're through, come over here and see Mr. Waddell. We'll have some paperwork for you. There's going to be conditions attached to your bail. If you violate any of those or conduct a hearing, could revoke your bail, put you back into it. All right. All right, once you sign your conditions of pretrial release, meet with Mr. Waddell and get your notice of appearance. You're free to go.
Judge, I'm sorry, what day was that set for?
June 13th.
13th, thank you.
Yes, Mr. Lee. Are you ready?
Yes, it's actually not.
William Goldner. CR 22376. All right, Mr. Bullner, set for pretrial.
Yes, Your Honor, we have no pretrial issues for the court at this time. I think we're ready to get to the docket call status.
You are Mr. Head available on June 13th or June 1st. One's better than the other.
13th, that's better, Judge.
13th.
Yes.
All right, Mr. Goldner, we're set for docket call on June 13th, 9 AM. Once you sign and get your notice of setting, you're free to go.
That's all I have. I think Steve, I think it's running 16.
Good morning, sir.
Morning, Your Honor. Mark Elliston, Representative Thomas Derek Norman. We just found out about the setting yesterday, so we filed a notice at representation letter yesterday.
Mr.
So-
Cormier, come on up. All right, Mr. Ellison, have you had an opportunity to view the indictment in this case, go over that with your client?
No, Your Honor, we just found out about the setting yesterday, but this, for purposes of arraignment, Mr. Norman waives arraignment, waives reading of the indictment, enters a plea of not guilty, and his name is spelled correctly.
All right, so y'all have reviewed the indictment together?
No, we have not seen the indictment yet.
Yeah, begs the question, how do you know his name is spelled correctly?
That's just correct on the docket.
Well, the docket doesn't always mean the indictment.
Okay.
So, State, could you assist the court in printing out a copy of the indictment for Mr. Ellison so that he can review that with his file?
Yes, Your Honor.
All right, Mr. Ellison, have a seat and I'll call you back up in just a moment. Ms. Curry's going to get you a copy of the indictment and we're going to do the arraignment you just said.
Thank you, Your Honor.
Do you have any other counsel that's ready? Mr. Wood, you ready? Benjamin Miles. CR 22-381. Mr. Miles is set for pretrial this morning.
He is, Your Honor. Good morning. We don't have any pretrial this morning. I've talked to Mr. Woodwalk about this case the past couple of weeks. I think we're headed in the right direction here, but I think we just put it on the docket call status. I hope as we get something back. So
All right, Mr. Wood, are you available on June 1st or June 13th?
June 13th, Judge, schedule works for us.
All right, court sets Mr. Miles for for docket call hearing on June 13th at 9 AM. And Mr. Miles, once you sign and get your notice of appearance, you're free to go.
Thank you, Your Honor.
Thank you, Mr. Wood. That's all I have. See. Hi, Judge. Good morning, Mr. Red. How are you?
I'm good, Your Honor. Esquivel's on our way.
Esquivel. CR 21-286. Motion to revoke. Go ahead, sir.
Your Honor, we spoke with the state. He's reached out to Terrell County in regards to the new matters. He and I both, and we have yet to hear back. We've agreed that he's going to attempt one more time to see if he could get a hold of somebody if their intention is to actually file these cases, which they have not yet been filed. And then he says to request 30 days, and if not, one way or the other, we'll have a solution to this matter on the next setting.
All right, court will set Ms. Esquivel on the contested docket on May 30th. At 9 AM.
Thank you, Your Honor.
Mr. Ellison, you ready?
Yes, Your Honor.
All right, Mr. Norman, come on back up, sir. All right, we're back on the record, CR 2364, State versus Thomas, Derek Norman. Mr. Ellison, has Mr. Norman had a chance to review the indictment? Is his name spelled correctly in the indictment?
He has, Your Honor.
Okay, and for the record, the court recalls that Mr. Ellison announced that Mr. Norman formally waives the requirements of arraignment. Court will enter his plea of not guilty into the record. We'll set this matter for a pretrial hearing. Mr. Ellison, are you available on either June 1st or June 13th?
Looks like I'm available June the 13th, Your Honor.
Okay, court sets Mr. Norman for pretrial hearing on June 13th. That'll be at 9 a.m. Mr. Ellison, what I'm gonna do is I need your client to go out to the Van Zandt County Justice Center, West Highway 64. Mr. Norman was arrested outside of Van Zandt County, but we do not have his fingerprints to report to the state. That's what we're required to do. So what I'm gonna do is give him what we call a processing order. He'll just take that out to the Justice Center. They're just gonna take your electronic fingerprints. They're not gonna change you out or anything like that. They're just gonna take you back, take your electronic fingerprints, and then they're gonna let you go, okay? But I've gotta have this report to the state, so I want you to do this upon leaving court today. They may not be able to get to you immediately, but I want you to just be patient with them. They're understaffed still. But go out there, be patient, show them your processing order. They'll get you handled as quickly as possible, okay?
Yes, sir. Can I approach to get that from you?
Yeah, we'll bring it to you. All right, do we have any other counsel that's ready? Mr. Manning, you ready? Joshua Chenault.
Yes, Judge.
Joshua Lee Chenault, CR 23-8. Mr. Chenault set for arraignment today.
Yes, Judge. I was just subbed in on Mr. Schmaltz's case. And so we have got a copy of the indictment. We've gone over that. Statement spelled correctly. He understands the charge of any question against him. At this time, he's pleading not guilty. Request to be sent on pretrial.
All right, court will enter Mr. Chenault's plea of not guilty into the record. Finds that he has waived the formal requirements of arraignment. Court sets this matter for pretrial hearing Thursday, June 1st.
Yes, Judge.
That'll be at 9 a.m.
Judge, while I was sitting up front, I saw like a couple of comments.
Mr. Dobbins, yeah, there he is. He's there. Mr. Dobbins, come on up. This is CR 21-58, State versus Randy Lee Dobbins, on a motion to revoke. Good, Mr. Manning.
Yes, Judge. I have been in communication with Mr. Dobbins. He has relayed to me some issues that he would like me to look into, discuss some of those with probation this morning. Request to be set on the motion to revoke, given time to resolve those issues.
All right, cool. We'll set Mr. Dobbins on the contested docket on Tuesday, May 30th. Objection,
Judge, that'll.
Mr. Dobbins, I want you to report to probation before you leave, okay? And remember, Mr. Dobbins, you're still on probation. Even though a motion for a vote or a motion to adjudicate file does not relieve you of the court order obligations, okay? So get your notes setting or meet with these ladies and they'll give you more information.
And with that, Mrs. Smith, be excused.
Yes, thank you, Mr. Please. Any other attorneys that are ready? Adriana Baker. Come on up. Baker, I know I'm probably not saying your first name right.
It's okay.
What is your first?
It's Detriana.
Adriana.
Yes, sir.
All right, Ms. Baker, this is cause number CR 2344. It appears to the court that you have been indicted with a second-degree felony offense of possession of a controlled substance. A second-degree felony in the state of Texas has a range of punishment, not less than 2 years in prison or more than 20 years in prison if you were convicted and sentenced, and a fine not to exceed $10,000. Do you intend to hire an attorney? Are you asking for a court-appointed attorney? Or are you asking to represent yourself?
I'm trying to hire an attorney. I just need a little more time if you can grant me that, sir.
If I grant you 30 days, do you believe that you can hire an attorney?
30 be good.
All right. So if I give you 30, I expect that you do something with the 30.
Oh, definitely. I will. I'm not trying.
I don't want you to come back and say I need 30 more.
Oh, no, sir.
So what I'll do.
Or is that the most time you could give me then?
That's most times I want to give you.
Okay.
I can give you as much as I want. That's as much as I feel comfortable with right
Oh.
now.
Okay, sir.
So, but what I'm gonna do is, I'm gonna set you out a little bit further actually, so be closer to 40, 45 days, okay?
Okay, thank you.
Set you out to June 13th.
Okay. I appreciate that.
So what I'm gonna do, Ms. Baker, is Deputy McLeish here has a notice of appearance, has a reset date. I want you to sign that, and we're gonna give you a copy of it to proceed back on June 13th.
And you are gonna give me a list of my charges?
No, ma'am.
Okay, I could just, okay.
You'll get that when you come back and you have an attorney and we're at arraignment. That's when you get a copy of your indictment. If you're representing yourself, you can go across the hall and ask. them
Okay,
for a
I just
copy
want
of
to get something so I can know exactly what, so I can show Lori.
I can write it on that form for you if you want.
If you don't mind,
Sure, if you don't mind.
thank you.
But you can go over to the clerk's office and ask for a copy.
Okay. Am I through for the day?
Let's see. I also need you to meet with my pretrial release officers. You've posted a bail in this case, so you're gonna have conditions of bail that you're gonna have to report, stay drug-free, drug test, all these different things. Okay, so meet with them. They'll go through that report. Wayne Crump. Yeah, sure. Mr. Crump, give me just one moment. Hey, come on up to the podium. Yes, sir. All right, this is cause number CR 2346, State versus Wayne Robert Crump. Mr. Crump, you are charged by indictment with a state jail felony offense of engaging in organized criminal activity. A state jail felony carries a range of punishment of not less than 6 months in prison or more than 2 years in prison, and a fine not to exceed $10,000 if you were convicted and sentenced. How do you intend to represent yourself in this case?
I'm a public defender.
So have you,
I filled out the paperwork today. They didn't give it to me before. I've never used a lawyer before, so I didn't know, so I'll have a representation.
all right, so you filled out the request for appointed lawyer. Okay, go ahead and have a seat, and then when they'll finish that, they'll bring the paperwork to me. We'll talk about it. Okay. Is there anyone else that will be requesting a court-appointed attorney and you've not filled out the paperwork? You've not filled out the paperwork. Sean Earl. Come on up, Sean. All right, this is cause number CR 2350, State versus Sean Clay Earl. Set for arraignment, Mr. Earl on the second-degree felony offense of assault, impeding breath or circulation of a family member, previous conviction, a second-degree felony that carries a range of punishment of not less than 2 years or more than 20 years in prison, and a fine not to exceed $10,000 if convicted and sentenced. Mr. Earl, you intend to represent yourself, hire an attorney, ask for a court-appointed attorney? Have you filled out the paperwork? When did you do that? Just now? Oh, so you still have it? Okay, all right. I didn't know that. Go ahead and have a seat. I'll call you back up. If you've completed it, you need to go turn it in. Down the hall to the left. All the way down to the left, right when you get to the men's bathroom, hang a left. Alfonso Perez. All right, this is CR 2367, State versus Alfonso Perez Jr. Mr. Perez, you are charged by indictment with a third-degree felony offense of evading arrest for detention with a vehicle. Carries a range of punishment of not less than 2 years or more than 10 years in prison if convicted and sentenced, and a fine not more than $10,000. Mr. Perez, are you going to hire an attorney?
I'm going to hire an attorney.
Okay, I give you 30 days or a little more. Do you believe that you can hire an attorney and come back, represent, and have them represent you?
Yes, sir.
All right, court will set Mr. Perez then for hearing on Thursday, June 1st. For status on hiring an attorney. All right, Mr. Perez, we'll see you back on June 1st. I expect you to have a lawyer with you. Mr. Perez, or Mr. Perez, go this way.
I gotta get my stuff.
We'll go around that way and get it. Charles, you ready? All right. Cause number CR 2385. How do you say his last name?
We'll let him say it, Judge. I don't want to mispronounce it. I say it Dingmans. I was thinking it's right. Mr. Dingmans is hard of hearing, Your Honor.
Is it Dingmans? Am I saying it correct? Dingemans. All right. This is cause number CR 2385, State versus Guido Dingemans, and we are set for arraignment today. Mr. Sorrells, have you had an opportunity to review the indictment with your client?
Yes, Your Honor.
And are you prepared for arraignment?
Yes, Your Honor.
Good. Good. Is his name spelled correctly? Does he waive the formal reading? How does he want to plead?
Yes, his name is spelled correctly. He waives formal reading and he pleads not guilty.
All right, court will find that Mr. Dingemans has waived the formal requirements of arraignment. His name is spelled correctly in the indictment. The court will enter his plea of not guilty into the record. Court sets Mr. Dingemans in for a pretrial hearing. Are you available on either June 1st or June 13th? June 13th. All right, court will set Mr. Dingemans in for pretrial hearing on June 13th. That will be at 9 a.m. Mr. Sorrells, do you already have discovery from the state? Make sure, if you don't, make sure that you have the electronic discovery available. If there's a video, it appears there probably will be a video in this case. Make sure you have that well in advance of June 13th, so you can file your pretrial motions at least a week before that, according to the code. Okay, thank you. All right, and Mr. Dingemans, I show that you're on conditions of pretrial release and you're reporting to a pretrial release officer. Is that correct?
Said that you're on, he asked you if you're on conditions of release and reporting to a pretrial officer. You're on the conditions of release and reporting to pretrial officer.
All right, Mr. Dingemans, I want you to come back and meet with my pretrial release officers, and they're going to talk to you about your conditions. I show that you're delinquent on some of your fees for pretrial release. Mr. Sorrells, if you want to come with him, that's fine as well. All right. All right, we'll see you gentlemen back on June 13th. Come on back this way with the ladies. Yes, absolutely.
Mr. Sorrells, the discs are ready in my office and on my discovery has been sent to you.
Thank you, Ron.
How are you? Are you here for school today, or do you have your own?
Sally holds it, but. Okay. We're the same.
All right, let's see. Isaiah Valencia Fulton, CR 2320, 21, and 23, and Mr. Valencia Fulton set for docket call on all three.
Your Honor, we would ask for 2 weeks, 2 weeks to call county. I just want to make sure that they're right together. We are ready. So I'll make sure that call time all those slides.
If there's something. All right, then court will reset Mr. Fulton. What is his next setting in Boston?
We plan on playing on May 8th.
May 8th. All right, I've got a setting on May 9th or May 11th.
May 9th is perfect. Your
May
Honor.
9th. Okay. All right, court sets Mr. Valencia Fulton for a docket call on May 9th. That'll be at 9 a.m.
Thank you, Your Honor.
And once he signs and gets his notice of appearance, leave me the yellow copy, it's ready to go, or leave me the white copy, he gets the yellow and he's ready to go. That all you have to do?
Yes, Your Honor. I'm here for you.
Okay. Mr. White, are you ready?
Your Honor. Wait.
Mr. Adams, you ready?
Sure.
Take your time, no rush. Josue Rodriguez, CR 18503. It's okay. You come up, Mr. Rodriguez, come on up and you can go across the front right there. There you go. All right, CR 18503. Mr. Rodriguez, is it my understanding that you want to hire an attorney to represent you on your motion to revoke?
Yes, sir.
All right, if I give you 30 days, do you believe that you can accomplish that?
Yes, sir.
All right, we'll reset Mr. Rodriguez to Thursday, June 1st. For arraignment, I'm sorry, for motion to revoke. Status on hiring an attorney,
I'm sorry, Howard, what was that name?
June 1st, 6/1. So, Mr. Rodriguez, we're gonna bring you a notice of appearance. You're gonna sign that, and it's gonna tell me that you've appeared today, and it's gonna give you the date for you to return. Yes, you're free to go. Thank you. Shane Taylor, CR 16278. All right, this is a probation extension, CR 16278. All right, Mr. Taylor. Looks like there's a request to extend your probation for a period of 1 year. It looks like you're set to expire next month on May 17th. You understand extending it 1 year would extend your supervision period until May 16th of 2024. Can you tell me why it is that we need to extend your probation? 5 days. Okay, and if we extend for that additional period, do you believe that that will help you come into compliance by paying all of your fines and fees on your probation? And Mr. Taylor, has anyone threatened, forced, or pressured you to extend your probation?
No.
Okay, and this is something that you're asking the court to approve for you? All right, the court will approve the amendment to the conditions of community supervision. The court will extend the probationary period of Mr. Taylor beginning May 17th, 2023 for an additional period of 1 year, with him expiring on May 16th, 2024. All right, Mr. Taylor, come on forward and we'll get you a copy over here. Thanks, sir.
Yes.
Ready? Carlos Gatlin, CR 21288. All right, Mr. Gatlin, sets the docket ball.
Yes, Your Honor, good morning. Last we were here, I had advised the court that I was waiting still for some video. I think I now have that video. Upon receiving it, viewing it, I filed a motion, motion to suppress. And I'm asking the court to set that for a contested hearing. I don't know if the state's had minutes to look at it. It was filed. I don't I don't see it. Really know. Mr. Gallen lives in Bossier Parish, so the further out the hearing, the more time he has to plan, make his travel arrangements, the better.
I've got this as being our final docket call. I show that he was set for pretrial 2 years ago. November of 21, then February of 22, and then 1, 2, 3, 4, 5, 6. This is the seventh docket call, so I'm a little confused as to why we're filing motions to suppress and asking for those hearings. When
It took us a while, the judge, to get the video in question, through no one's fault other than scratch CDs, DVDs, that sort of thing. The issue that I've had the issue that I've had in Mr. Gallen's case is the law enforcement's probable cause for the stop is represented in the reports as being because of an improperly illuminated rear license plate at night. I've always had a photograph still from what I think was the dash cam video footage that shows the license plate illuminated, and to not wanting to rely solely on that video still, that photograph, it has taken it. I wanted to, of course, to have the dash cam footage that we've had that it's been a challenge to get, and we got that within the last couple of 6 weeks, I think. And based on that, I've finally had enough to be confident to file a motion to suppress.
you're responsible state.
Judge, Mr. Adams is correct. There was some technical issues copying it. There was also, I believe that was copied from Mr. Adams. Probably about, it appears to be September of last year, but there was also an issue with, I believe that Mr. Gallen missed court for some reason. I believe there was a reason or excuse for that, but there was a substantial period of time in between the last settings. Looks like this was last set 8/11, and then again for 8/11 last year, then 4/4 this year, and 4/25. So in between that time, we turned that over to Mr. Adams, but I don't know whether he had a chance to speak with his client during that time or anything of that nature. Obviously, if there's some constitutional issue, I'd rather we take that up pre-trial rather than in trial, which Mr. Adams would obviously be entitled to do. So the state's not opposed to setting for contested hearing, making sure we can get that, but as soon as possible, and then hopefully we can get this resolved.
All right, court will set the defendant's motion to suppress for hearing on May 30th. 9 a.m. John McLeod, CR 22-334. All right, Mr. McLeod is set for pretrial.
Yes, Your Honor. Last we were here, we had on file a motion requesting an in-camera review of some DFPS records. In this case, there's an alleged child victim, and that child has been the subject of DFPS investigation in the past. It is my understanding that the district attorney's office has requested those records, but they haven't been released yet.
No, Judge, I'm sorry, to correct the record, state has not requested that yet. At our last setting, Mr. Adams had filed a motion. We had not received a copy of that yet. I have reviewed it now. State will be issuing a subpoena for those records. There shouldn't be a problem, but we have not completed that yet. And so once we do that, it's usually between 30 and 60 days before we get a return on that. But he has told me specifically what we're requesting, and we're gonna get on that this week.
All right, court will set Mr. McLeod for a status on DPS records. We'll set this on available June 1st or June 13th.
Thirteenth is fine, Your Honor.
All right, court sets Mr. McLeod on June 13th.
Your Honor, that's all. Those are all the items I have on court stocking. Maybe it's,
Have a whirlwind day for you.
no, it's not what I anticipated doing this morning. Say la vie.
Or Mr. Adams.
I was gonna ask any questions. You want to go on first? Mr. Watson. Christopher Storm Watson, CR 22198.
Your Honor, we were set to complete today. I just want that to say that, his family stand part in this, so we're going to be set.
Sizel. Mr. Watson, Mr. White's announced that no plea today, due to request by the victim's family to be a part of the plea. Is that correct?
Judge, that is not my case, but I'm confident that if Mr. White's been communicated that by our office, that that's correct.
So, what is the anticipated plea that the victim's family is?
Well, I mean,
Allocution.
that's what it is. We've already come up what we're going to be trying to resolve this. The family wants to be able to address this.
We know how long we need to reset to allow.
30 days.
Do we need that much? to do that?
Judge, I don't. Short line space, the timeline. We have no idea. I think pure speculation.
Basically,
If we have a resolution, I'd rather do it sooner than later.
Judge, I'm checking my big coordinator right now. Ready to have just a minute. I'll let you. I would not anticipate pulling off, but let me check.
All right, go ahead and have a seat, Mr. Watson. I'll call you back up in just a moment. Who else you ready on, Mr. White? Mr. Atkins. CR 22-1 -236 -368. Show that we're set for docket call on all three charges. Go ahead, Mr. White.
Your Honor, we are going to need to set. Anticipating that this will be the same date or some of the 7% requirements taken into this. We would also request 30 days. So we have policy of our parents.
The objection is taken.
There you are.
All right, well, we'll set Mr. Atkins for plea on Thursday, June 1st. 1:30. Mr. Watson, come on back up. All right, Mr. White, are you available on either Tuesday, May 9th or Thursday, May 11th? Please. All right, well, we'll set Mr. Watson then to enter his plea on Tuesday, May 9th. And we're gonna do this at 11. That way, if we do have an allocution, we should have some time. May 9th at 11 a.m. You're free to go.
When you get a chance, when you get a chance. Yes, I have. Straight away.
Okay. All right, Kalen Cheatham, CR 22205.
Morning, Ron.
Sir, how are you?
Good. How about yourself?
Good. All right, Mr. Cheatham's here for a plea, is that correct?
Yes, Judge.
All right, Mr. Cheatham, if you will, sir, raise your right hand. I'm going to place you on oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. All right, thank you. Lower your hand. During the plea, just make sure you speak up loudly and clearly so I can hear you. So my court reporter can take down what I'm going to say, okay? All right, your name is Kalen David Cheatham, is that correct? And Mr. Cheatham, are you a United States citizen who reads, writes, and speaks English? You gotta let me finish so that she can take down what I say and then she can get your response, okay? All right, so are you a United States citizen who reads, writes, and speaks English? Have you ever been diagnosed with a mental condition? In this case, you're represented by your attorney, Mr. Andrew Dahman. Are you pleased with his representation of you? Do you feel like you've had enough time to talk with him about your case and have all of your legal questions answered? Is there anything about the paperwork that you've read over and signed today that you do not understand? Mr. Dahman, do you believe Mr. Cheatham to be competent today?
I do, Your Honor.
Have you explained to him his rights as they pertain to this case and also the advantages and disadvantages of the deferred adjudication plea?
I have, Your Honor.
And do you believe he understands his rights and he's making intentional, knowing, and voluntary waiver of certain rights within this plea?
I do, Your Honor.
All right, Mr. Cheatham, you are charged by indictment. I'm sorry, you're charged by information. Is it information or indictment?
It isn't, it was indicted. It just shows up as information on the judgment.
All right, so we need to change that. We need to change the judgment on this to say the charging instrument is an indictment, not an information. On Mr. Cheatham. So, Mr. Cheatham, you're charged by indictment with a third-degree felony offense of evading arrest or detention with a vehicle. That offense carries a range of punishment of not less than 2 years in prison or more than 10 years in prison and a fine not to exceed $10,000. That's if you were to be convicted and sentenced on that offense. I see that the plea agreement in your case today is that you're wanting to plead guilty to that crime in exchange for the state's recommendation that the court defer a finding of guilt, place you on 3 years community supervision plus a $1,500 fine, court costs, reimbursements. Is that your understanding of the plea agreement, Mr. Cheatham? Do you understand, Mr. Cheatham, if I were to approve this plea agreement today to place you on deferred community supervision, I would be considering the evidence today, if there's enough evidence to convict you of the offense, or could take that into consideration, defer a finding, meaning the court would not convict you today, but the court would put you on a deferred community supervision. And during that period of 3 years, if at any time you violate any of the terms and conditions of your community supervision, the state could file a motion to adjudicate you. That means to adjudicate your guilt, to convict you. The state could ask the court to do a number of things, including convict you, revoke you from your community supervision, and assess you a prison sentence all the way up to the maximum 10 years in prison. And understanding the advantages and the disadvantages, and the risks with that plea agreement, you still wish to go forward? Then, Mr. Cheatham, I would ask you, how do you plead to evading arrest or detention with a vehicle? Are you pleading guilty to that crime because you are guilty of committing that crime? Has anyone threatened, forced, or pressured you to plead guilty today? All right, the court accepts the defendant's plea of guilt at this time. Mr. Dodd, any objections to the state's evidence supporting the plea?
No, Your Honor, we stipulated to it with no objection.
All right, the court will admit the stipulation of evidence in State's Exhibit 1. The court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Judge, only briefly, probation has asked me to ensure that Mr. Cheatham is a resident of Texas. Okay, that was the information we had, but probation wanted to make sure this wasn't transfer. I forgot to ask Mr. Dahman to ensure that that was the case, so I just wanted to check and make sure. Beyond that, state has nothing further. We arrested close.
You live in Dallas County, correct?
All right, the court is going to take judicial notice of the defendant's judicial confession. Court's going to review State's Exhibit 1. All right, the court has reviewed the evidence. The court finds sufficient evidence to convict Mr. Cheatham of this offense. Court will follow the plea agreement between the state and the defense. Court hereby defers the finding of guilt for Kalen David Cheatham for evading arrest for detention of the vehicle, third-degree felony. Places him on community supervision for a period of 3 years. Assesses a $1,500 fine, $290 court costs, $35 reimbursement. All right, Mr. Cheatham, you're hereby remanded to the custody of the probation department so they carry out the terms and conditions of the sentence. I'll have you come forward with deputy police to be fingerprinted. And then you'll step over here with the probation officers and they'll give you more. Yes, thank you, Mr. Dolan.
place. So judge to it. So, yeah, all we did was change it. Judge, how much you do this real fast, just so I'm not changing sign judgments. All we did was change indictment to, from information to it.
Bud, you ready?
Yes, sir.
Who you ready?
Can we call Mr. Payne?
Daniel Ryan Payne, CR 22-246. All right, we're set for docket call today.
Your Honor, we're gonna ask the court to set this plea on May 9th. Got enough docket.
Yes, I believe we can make that. All right, court sets Mr. Payne Danner's plea before the court. Will that be an AM plea or a PM plea? All right, that will be Thursday, May 9th. And Mr. Payne, once you sign, you get the yellow copy. You ready on it?
Let's call him Sutton.
Ivy Sutton, CR 2318. Sutton, separate pretrial.
Your Honor, we're gonna ask the court. I believe you got a June 13th day. Could we set it for plea on that day?
All right, so no pretrial motions.
No pretrial, Your Honor.
All right, court finds there are no pretrial motions. Court will set this Sutton in for plea on June 13th. Is that AM?
It's
All right, court sets Ms. Sutton in on June 13th. Plea. Next is what?
Mr.
Carl Buck McVeigh, CR 22-223. Mr. McVeigh is set for pretrial today.
Your Honor, we'll ask the court to set that on June 13th.
All right, court will set Mr. McVeigh for plea on June 13th at 9 AM as well.
Yes.
9 AM, once you get your yellow copy, you're ready to go. Colton Green, CR 2303.
Your Honor, I believe the state would join me if we could have this reset to June 13th. Give us a chance. Hope it comes some sort of resolution.
All right, court will set Mr. Green for docket call on June 13th. 9 AM. Mr. Green, once you sign and get the yellow copy, ready to go.
Your Honor, that's all I have this morning. I've got.
So you're reporting to the jail. Yes. Okay. Cody Wheeler. This is sanctions court hearing CR 18342. All right, Mr. Wheeler. I know say that you have a lack of participation in your community service. Also says you got upset, slammed the doors over at the office visit in March. Upset because you were being put in sanctions court. And they believe that the only way you're going to participate is having you come to court every month. What do you say about that? Are they gonna have problems out of you? All right, so what I'm gonna do is I'm gonna set you for another sanctions court hearing. I'm gonna give you 3 things that you've got to do. And for every one of these things that you don't do, there's gonna be a day in jail tied to it. Okay? You're gonna have to work 20 hours of community service because you're delinquent by the bid. Gotta get you caught up on that. You gotta work 20 hours community service, you can't donate it. That actually work it. And you've got to do All right. All right, so, Mr. Wheeler, the first thing is that you gotta do 20 hours community service. Second thing is you gotta pay $65 to probation department. And you gotta pay $435 in your restitution that you owe for your case. That's $500. Okay. So if you don't pay your probation fee, that's a day in jail. You don't do your community service, that's a day in jail. If you don't pay your restitution, that's a day in jail. So those are gonna be your sanctions for non-compliance. You understand that? Just wanna make sure that we're on the same page.
Yes.
Okay, so I'm gonna reset you until June 1st, give you time to get all that done. Okay. So make sure that you got your community service turned in to your probation officer. Well before June 1st, so that they can document the records, don't bring it in court that day.
Yes.
Okay. See that? All right, we'll see you back on June 1st. All right, Mr. Schmidt, are you ready on you?
Yes.
Who would you like to call first?
Um, so,
Lisa Holdren, CR 2353. All right, this is cause number CR 2353, state versus Lisa Council Holdren. Court finds that Ms. Holdren has been indicted with the state jail felony offense of theft of property, $2,500 to $30,000. Court finds that she's requested court appointed attorney. Court finds her to be indigent for purposes of the Sixth Amendment. Court has appointed law Mr. Schmidt to represent Ms. Holdren. Mr. Schmidt, have you had an opportunity to review the indictment of Ms. Holdren?
we have judge, and her name is spelled correct. Wait, one reading, she understands the charges. We are not asking this.
All right, court will find Ms. Holdren has waived the formal requirements of arraignment. Court will enter her plea of not guilty into the record. And the court sets Ms. Holdren for a pretrial hearing be available on Tuesday, June 13th.
Yes. I've been, setting up pre-trials.
All right, court will set Ms. Holdren then for a pretrial on June 27th. 9 a.m. And Mr. Schmidt, before Ms. Holdren leaves today, I don't know if she has signed her conditions of pretrial release, but she'll need to do that. Wayne Robert Crump, CR 2346. All right, court finds that Mr. Crump has been indicted for the state jail felony offense engaging in organized criminal activity, that he has requested a court-appointed attorney. The court has reviewed his application, finds him to be indigent for the purposes of the Sixth Amendment. The court has appointed Honorable Richard Schmidt as counsel. Mr. Schmidt, have you had an opportunity to with Mr. Crump?
We have viewed it, understands what he's charged, main spoken, plead not guilty.
All right, court will enter Mr. Crump's plea of not guilty into the record. Finds that he's waived the formal requirements of arraignment. Court will set Mr. Crump for a pretrial hearing on Tuesday, June 27th, 9 a.m. I don't know, if Mr. Crump's on conditions of pretrial release yet. If not, I wanted to go ahead and check in just in case it's not. Radio, Mr. Earl. Yes, sir. Sean Earl, CR 2350. Court finds that Mr. Earl has been indicted with the second-degree felony offense of assault, aiding breath or circulation of a family member with previous conviction, a second-degree felony. Court finds that Mr. Earl is indigent today for purposes of the Sixth Amendment, has appointed the Honorable Richard Schmidt. Mr. Schmidt, have you not had an opportunity to review the indictment, Mr. Earl?
We did, Judge. It's changed, don't regularly understand the charges filed against him. Wait for the plea. Ask for the trial.
All right, court will enter Mr. Earl's plea of not guilty into the record, finds that he's waived the requirements of arraignment, sets him for pretrial hearing on June 27th at 9 a.m. Mr. Earl, I need you to report to the pretrial release officers to sign your conditions of pretrial release. Did you get the yellow copy? Free to come over here and make this on. Sane. All right, this is cause number CR 2371, State versus Todd Daniel Sane. Mr. Sane, the court has reviewed your application for court-appointed counsel. The court finds that you are not indigent at this time and not entitled to an appointment of an attorney. What I could do is I could reset you until June 13th and give you time to try to hire an attorney. You want to do that? All right, the court sets Mr. Sane then for status of hiring attorney June 13th at 9 a.m. So Mr. Sane, I would just advise you to speak to as many attorneys as you can to determine if someone can take on your representation based on what you're able to afford. Don't just assume when you call one attorney that that's going to be the same for all attorneys. Okay, so when you come back on the 13th, I really expect you to have an attorney. If you don't, we have further conversations about that. And I need to see some active involvement on your part trying to hire an attorney. Okay. Free to go. All right, we'll call CR 22195, State versus Kenneth Lee Taylor. He was verified in custody in Russ County yesterday, so we will reset this for status of custody on June 1st. Joyner, come on up. Cause number CR 2127, state versus Alicia Renee Joyner, sanctions hearing. One of the last one. No, right here. Right. So, Ms. Joyner, I showed that there is a one. So, that means they should take it. You'll have an opportunity. Are they here with you in the court? We'll make sure that someone, we'll make sure you have an opportunity to talk. Ms. Joyner, are they adult kids or kids? Are they sitting downstairs? Bring them in. She probably. Yeah, if it's a true motion or vote, you're not entitled to bail, but you hire an attorney or request a court appointed attorney to send a motion that they can make. No, if you hire an attorney and a court appointed attorney, they can file a motion. Bail. Prior to it. You know if you'll be requesting a court appointed attorney or hire an attorney. I'll have Miss Taperham come bring some paperwork in just a moment. Or whenever you get to the jail out there, just ask for paperwork, they have. Fill it out. Okay. We'll be talking about that next year. For the record state, CR 22193, Jordan Owens, Mr. Owens is in custody here in Maine's End, and so his hearing should be at 1:30. I think he's listed as Owens here in Matillo at jail or vice versa, so Mr. Desmond Cooks will be appearing. Saturday.
Tyler.
All right, the court has had the following names called, court called each of these names at 9 o'clock. Docket. There was no response. Court has had each name called loudly distinctly 3 times, with no response. Court has issued judgment not size and the escape business for the following individuals. Marshall Deshaun Parker, CR 2331. Claude Raymond Souls, CR 246. Ivan Molina Hernandez, CR 2362. Call Valley. Courthouse. Stand in recess and wait for Mr. White for his plea. All right, Ms. Polans, if you'll come forward, please. It's cause number CR 22-361, State versus Julie Lutz Polans. Ms. Polans, if you'll raise your right hand, I'm gonna place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help me God. All right, lower your hand. Your name is Julie Lutz Polans, is that correct?
Yes, sir.
Ms. Polans, are you a United States citizen who reads, writes, and speaks English? Have you ever been diagnosed with a mental condition?
Yes.
Can you tell me about that?
Bipolar.
Okay, when was that?
A long time ago.
Are you on medication or under treatment? You gotta let me finish my question. First of all, you don't even know what I'm gonna ask. You already answered. Hang on. That's it. Just listen. It's important. I've gotta ask questions and then I've gotta hear answers. Even more important than that is Ms. Grisham here has to be able to type down what I say and what you say. And she can't do it if we're talking at the same time, okay? So are you on medication or undergoing treatment for bipolar?
No, sir.
Do you feel like you need to be on medication or undergoing treatment for bipolar?
No.
In this case, you're represented by your attorney, Mr. Jeff White. Are you pleased with Mr. White as your attorney?
Yes.
You feel like you've had enough time to talk to him about your case and that you've had all of your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've read over and signed today that you do not understand? And you're swearing that telling me that you swear that your signature is true and correct, that you've only signed once you knew what you were signing.
Yes.
Mr. White, do you believe Ms. Polans to be competent today?
I do, Your Honor. She's got to make the decisions that she's made.
And have you seen any evidence that her previous diagnosis of bipolar is in any way inhibiting her from having a rational understanding of the proceedings here today?
Not today or any other time.
And you've explained to her, Mr. White, her rights as they pertain to this accusation, and also with regards to the plea agreement with the advantages and disadvantages of a deferred adjudication plea.
I have, Your Honor, she's very aware that's my role. I have her take this plea, actually, if I didn't think her decision.
Thank you, Mr. White. All right, Ms. Polans, you are charged by indictment with a first-degree felony offense of manufacture or delivery of a controlled substance in penalty group 1, greater than or equal to 4 grams, less than 200 grams. A first-degree felony, if you were to be convicted and sentenced for this offense, would carry a range of punishment of not less than 5 years in prison, up to a maximum 99 years or life in prison, and a fine not to exceed $10,000. Do you understand that if the court approves this plea agreement today, which appears to be that the state's recommending that a finding of guilt be deferred after you plead guilty to the crime, that you be placed on 6 years community supervision, that you pay a $2,500 fine, court costs, restitution, reimbursement fees, and as part of the plea agreement, the state's dismissing a few other criminal offenses, driving while licensed, invalid with previous convictions, and unlawful carrying of a weapon. In addition, there's a weapon forfeiture associated. You understand that if the court approves this plea agreement and places you on probation, that during the next 6 years, if you violate any of these conditions of community supervision that you've read over and signed today, that the state can file a motion to adjudicate your guilt, bring you back before the court, and could ask the court to conduct a hearing, allow them to put on evidence. And if they prove to me that you have violated any of the terms of your community supervision, the court could do several things, including convict you of this offense, revoke that probation, and sentence you in prison up to 99 years or life, maximum, all the way down to the minimum 5. Do you understand that? You understand that's a serious risk for someone who either 1, doesn't intend to comply with probation, or 2, doesn't believe that they can reasonably comply with probation. Do you understand that?
Yes.
Understanding all of those things, you're telling me that this is the plea agreement that you want the court to approve today? All right, then Ms. Polans, I find that I've admonished you with regards to the criminal accusation, the range of punishment, and the plea agreement. So at this time, how do you plead to manufacture or delivery of controlled substance, penalty group 1, greater than or equal to 4 grams, less than 200 grams, a first-degree felony?
How do I plead?
Are you pleading guilty to that crime because you are guilty of committing that crime and for no other reason? Has anyone threatened, forced, or pressured you to plead guilty today? The court will accept the defendant's plea of guilt. Mr. White, any objection to the state's evidence? No objection. All right, state's evidence and exhibit 1 is admitted. The court takes judicial notice of the defendant's judicial confession. Anything further from the state? Defense. Okay. All right, court will review the evidence. All right, the court has reviewed the evidence and finds that there is sufficient evidence to convict Ms. Pullins of this offense. The court will follow the plea agreement reached between the state and defense. The court hereby defers the finding of guilt on the charge of first degree felony manufacturing of controlled substance group 1 between 4 grams and 200 grams. The court places Ms. Pullins on 6 years community supervision, orders her to pay a $2,500 fine, restitution of $180. Court dismisses under section 1245. DA 2022-574. DA 2022-0573. Court also assesses court costs of $290, reimbursement fees of $35, and restitution of $180. Court also finds that a weapon was seized and is hereby forfeited. Within this agreement, court finds specifically it is a Jimenez Arms Model 380 semi-automatic pistol, serial number 1529068. Court wants that to be forfeited. Possible terms outlined. Ms. Pullins, you're hereby remanded to the custody of the Van Zandt County Probation Department, so they can carry out the terms and conditions of the sentence. I'll have you come forward to give your fingerprint. Then you're going to meet with the officers over here and they'll tell you more about the commission.
Thank you, Your Honor.
All right, that's the morning docket court. Docket at 1:30.